Today we will discuss employment law, and we will give you the best advice for maximizing your chances of getting high grades. First of all, planning is the most important. You need to be able to not only work hard on your revision and try to revise everything you've learned on your course, but you should really plan it in a very smart manner. How do you do that? You can ask for past exam papers to your professor, or it should be provided to you on the university's portal. But if it's not provided, you can ask for it to your professor, and you can review your past exam papers and identify the questions that usually come up on the exams from year to year. Once you have identified the topics of revision according to the past exam papers, choose the ones that you feel more comfortable with. For example, if you like employment status topic, and you feel that you will be able to provide a better answer on that than for a problem question on unfair dismissal, for instance, then you can select that topic that you feel more comfortable with for your revision. Once you have selected the right amount of topics for revision, read our notes as well as your lecture slides on those topics, and practice answering problem and essay questions from your past exam papers, as well as our example essays that we provide in Simple Study. Make sure that the number of topics you revise match the number of answers that you need to provide on your exam. For example, if you will be given a set of 6 questions from where you have to answer 3, you will need to revise at least 3 topics. Possible topics that very often come up on employment law exams are employment status, unfair dismissal, redundancy, and employment contract. Those are very, very often examinable topics that I suggest you revise. However, all the exams can be different. Therefore, it is your responsibility that you double check what is required from you in your particular course, in your particular exam, and you plan your revision accordingly. If you need help with that, if you're struggling with planning your revision, the best way you can get the help you need is to book an appointment, book a tutoring session with one of our tutors, and our tutor will be able to help you to plan your revision in the best way possible for you to maximize your chances of getting high grades. Before we move to in-depth discussion of the mentioned topics of employment law, we'd like to remind you the style, the structure that you need to follow when you're answering problem questions and then essay questions. In a problem question, a lot of students repeat the facts of the case in the beginning, which is a big mistake, and you shouldn't do that. In problem question, you can just start straight away with discussing the first legal issue that comes up on the facts given to you. The overall structure is IRAC. Most of the students have heard about it, but it's very rarely followed in the correct manner. You need to understand that IRAC structure is not just a recommendation, but it's mandatory for you to follow it in problem questions if you want to get a high grade. IRAC structure gives the examiner a very clear overview of your legal knowledge and your ability to provide arguments and analysis. Therefore, with every single legal issue that comes up on the problem question scenario given to you, you're required to first state what is the legal issue that you are discussing. Secondly, provide overview of the relevant laws. Relevant law can be statute or cases, both. You should provide both primary laws, and then you need to apply the law that you have discussed to the facts of the case and provide arguments. What would be the most likely outcome of the case, and what would be the most likely view that the court could take in this case, given the circumstances. Essay question is a bit different. Here we do have an introduction. Introduction could be about 10% of the total word count. And in the introduction, you really need to introduce the topic at hand. You really need to introduce the legal issues that are involved with the essay question that has been given to you. For example, I've seen a lot of essay questions about employment status and Uber case that has modified the law that we had before on who can be a worker and who can be an employee. If you have a essay question on that topic, you really need to explain what was, very briefly, what was the law before Uber case, and very briefly introduce the main principle that Uber case has brought along, and then announce the plan of the essay in the thesis statement, where you state what will be the first thing that you will be discussing, what will be the second thing, and where is your discussion going, what would you be concluding at the end. Very important when you, in the body paragraphs, when you make arguments, is that you make arguments for both sides of the question. Law school is preparing you for being a lawyer, and a good lawyer should be able to provide arguments for both sides. If you're a lawyer, you should be able to act both for the defense as well as prosecution, if it's a criminal law case, or if it's a civil law case, then it will be claimant and the defendant. So similarly here, you should be able to provide arguments of all sides rather than just one side. Doesn't matter what you believe in, what you think is right. You need to be able to be neutral in your essay and provide arguments for both sides if you want to get a high grade. All your arguments have to be backed up by cases. If it's not backed up by cases, you will get a low grade. Everything you say has to be supported by relevant legal authorities. A lot of students in essay questions become very descriptive. So this is a very important thing for you to watch out for. Make sure that you don't dive too much into the overview of the law. You only explain the law that refers to the arguments that you're going to make. If you're not going to use the cases you describe in the essay for your argument, then you would rather not mention it, because if you mention a lot of cases, it feels like you are just writing everything you know about the topic rather than actually answering the question. And that's how most of the students lose a lot of marks. Make sure that you really only discuss the legal authorities that are first relevant to the question asked, and secondly, relate to the arguments that you are going to make in the essay. The first topic that we will discuss is employment status. There is a distinction between these two notions, two concepts in employment law in England and Wales. Employee and a worker. Those are similar, but have different rights. Section 230 of the 1996 Act is an important section for you to mention if you have a problem question or an essay question on this topic. In a problem question, you should define the employment status under the Employment Rights Act 1996. Definition of an employee and a worker is provided there, so sections 230 and 231 and 3. Definition under section 230. Employee in this act means an individual who has entered into or works under a contract of employment. Therefore, the most obvious form of employment is having a contract of employment. In this act, contract of employment means a contract of service or apprenticeship, whether express or implied, and whether oral or in writing. In this act, worker means an individual who has entered into or works under a contract of employment or any other contract, whether express or implied, and whether oral or in writing, whether the individual undertakes to do or perform personally any work or services for another party to the contract whose status is not by virtue of the contract, that of a client or customer of any profession or business undertaking carried on by the individual. Therefore, there is a difference between what is a worker and what is an employee, but there are some overlaps. That is why we had a lot of cases that raised this issue, because Section 230 doesn't really make it very clear what is the main difference between being an employee and a worker. That is why if you have a problem question on this area, you really need to use the case law here. Because case law is actually providing a lot clearer guidance of determining if the party you're advising in a problem question is an employee or a worker. It has a very big importance. So this is these are the considerations you need to take into account when you're discussing whether an individual is an employee or a worker. You shouldn't avoid treating this as a checklist, but you should rather go through the relevant case law and apply it to the facts of the case and make arguments then. The important factors that you need to take into consideration are the following. Does the individual pay tax or national insurance? How the arrangement can be terminated? Does the individual get sick holiday pay? How integral is their role? Who has the tools or equipment? In other words, if the employer pays the employees national insurance and taxes, that is the first indication that it will be more likely employee rather than a worker. If also the arrangement can be terminated if the employee, the individual can anytime terminate the agreement, the arrangement, that means that he has more freedom and could be the indication of a worker. If he's getting holiday pay or sick pay, that's also indication that he's more likely an employee than a worker. Integral is the role, so how important is the person to the company, and who has the tools or equipment. So who, if there are any tools or equipment, the most obvious example could be if someone works for a company, for a technology company, and if he's working on his own computer or he's working with a company computer. If it's a company computer, that is not a conclusive proof that he's an employee, but it is a point in favor of him being an employee if there ever arose a dispute over this question. The modern forms of employment used by technological companies have caused the courts to reconsider the definition of an employee. The case of Uber will have a significant impact on determining the employment status. Before, we saw more traditional types of employment, like when people were working in factories, for example. It was more straightforward. However, right now, we have seen more elaborate forms of arrangement between companies and individuals. Consider the example of Facebook. Facebook has content creators. And if someone creates a lot of content that attracts lots of advertising, then some commissions are paid from the advertising revenue of Facebook. Is that person an employee of Facebook? That's, or even YouTube has a similar business model. However, Uber was a bit different because in Uber case, the drivers were supposed to be self-employed, as the contract said, but they were getting penalized for turning down the job. So they had a right to cancel their rides, but there was a limit as to how many rides they could cancel, and if they had to cancel more than the limit, then their profile was penalized. Therefore, it triggered the discussion towards them being a worker rather than a self-employed person. So there are three types: self-employed, worker, and employee. Now we're going to discuss how Uber case changed the law. Uber case changed the approach taken in the earlier decision and held that employment status should not be determined by simply interpreting the contract between the parties. The wider picture should be regarded to assess all the background facts and decide if the company has sufficient control of the person. The reason for this approach is because the arrangement between companies and individuals in 21st century is no longer straightforward like it was before. Therefore, for a court to really understand if the person is an employee or a worker or self-employed, they have to really take into consideration all the background circumstances, the level of control the company has with the individual, and rather than just the employment contract, because the employment contract may say he's a self-employed person, but circumstances or the background circumstances may indicate otherwise. That is why, for achieving the most fair outcome in these kind of cases, the courts had to change the law. Uber drivers were found to be workers and not independent contractors. The reasoning for it was that all the drivers were free to choose when and where to work. Once they had logged on to the app, their choice about whether to accept requests for rides was constrained by Uber. Uber controlled the information provided to the driver, who was not informed of the passenger's destination until they were picked up. Uber also monitored the driver's rate of acceptance and cancellation of requests and imposed penalties. Whether the cancellation rate exceeded a certain level by logging the driver off the app for a period of time. So that was that indicated that Uber actually had control over the drivers, and that level of control was not the one characterized by being an independent contractor, but they were not employees either. Although drivers were free to choose when and where to work, once they were logged onto the app, their choice was limited. Therefore, that indicated a big that indicated that Uber actually had control. You can read an example essay question on employment status that we have on our website. Good practice would be if you read the question, answer it yourself, applying the law that we have discussed, as well as more details of other cases and statutes as well. And then compare your answer to our answer. That would be really the best practice for you to prepare for your exams. Now we're going to discuss unfair dismissal and the relevant statutes for it. Key provisions from the Employment Rights Act for unfair dismissal is section 94, 98, 95. 94 is the right not to be unfairly dismissed. 98 sets out the process to determine if a dismissal is fair. Section 95 states that dismissal can arise in three situations: when the contract is terminated by the employer, when the employee was employed under a limited term contract and that contract terminated without being renewed, the employee's contract was terminated in the circumstances without notice being given to them. In a problem question on unfair dismissal, most probably you have to discuss if the employee was treated fairly. The employer must show that he has a good reason to dismiss the employee and that he acted fairly in the way the dismissal was handled. You need to discuss relevant cases and argue if the employer in the case at hand acted fairly. So this will be most probably your main objective in a problem question on unfair dismissal, to demonstrate to the examiner that you understand the law on unfair dismissal, you are able to apply the law to the facts of the case correctly and provide convincing analysis. Restrictions to bring an unfair dismissal claim: 2 years of continuous employment. Reason for dismissal shall be unfair. So those are the two reasons that triggers the unfair dismissal claim. That could be your starting point. Has the person been employed for 2 years? and was the reason for dismissal unfair? If so, show the facts from the scenario given to you that says that he was indeed employed for more than 2 years, and that indicates the reason for dismissal was unfair as per the Employment Rights Act 1996. In certain situations, the reason for dismissal will be automatically unfair. If one of these reasons apply, then the claim can be made to the employment tribunal, even if the person worked for less than 2 years. So if the problem question given to you says that the individual was employed for less than 2 years, you can see if any of the automatic claim situations apply. These are when membership of the trade union, exercising statutory rights such as paid holiday, weekly and daily rest breaks, participation in protected industrial action, transfer of undertaking protection of employment, maternity, paternity leave, health and safety, exercise of rights under the Working Time Regulations 1998, the Public Interest Disclosure Act, the National Minimum Wage Act in relation to tax credits. The burden of proof is on the employer to show that the reason for dismissal was fair. So if the employee is suing the employer for unfair dismissal, it would be for the employer to prove that he was not dismissed unfairly. The reason must be one of the 5 permitted reasons set out in section 98. And if the reasons do not fall under one of these 5, the dismissal would be unfair. There is also redundancy. Redundancy at section 163 of the Employment Act 1996 sets out how a person can be made redundant. An eligible employee dismissed by reason of redundancy is at minimum entitled to a statutory redundancy payment. A redundancy payment is a reward for past service. An eligible employee is entitled to receive the full statutory redundancy payment if he or she finds another job immediately. Who is entitled for redundancy payment? The employee has to be in employment for 2 years at least, continuously, as per section 155, and where an employee is dismissed by reason of redundancy, there may also be a claim for unfair dismissal. Therefore, you need to decide in the problem question that has been given to you whether it's unfair dismissal, whether the redundancy law applies, apply the relevant statutes, relevant case law, and make conclusions. What would be the most likely outcome? I highly recommend you to have a look at our notes and case summaries in employment law. It gives you a very good yet simplistic overview of what you need to know to be successful in employment law and to achieve high grades. Notes are a great resource full of exam tips like the ones I've been giving to you now that help you understand how you're supposed to apply your knowledge to common problem question, essay question scenarios. Cases are also very important. Employment law has quite a dependency on case law. There is an employment statute, but for a lot of matters, you really need to rely on case law to be able to provide a holistic overview of the law and analysis. Therefore, I highly recommend you to read the relevant cases to make sure that the level of analysis you provide in the exams is sufficient enough to get a first class. Also, very important is for you to practice. One thing is to know the law, and the other thing is to be able to apply the law to the facts of the case. And the only way you can learn how to answer problem and essay questions is by practicing a lot. It takes time. Therefore, start as soon as possible. Answer all the model questions we have on the website, and then compare your answers to our answers. That would be a really good way for you to practice. Also, it's highly recommended that you read our exam tips, and if you can, it would be great if you can also book a few tutoring session to make sure that you have the chance of one-to-one meeting to our tutor who can teach you the best practices for you to maximize your chances of getting a first class. Quizzes and flashcards are also provided for you to memorize the main cases and principles easily. To sum up, you need to analyze your exam requirements. What are you supposed to do? And do the selective studying. Select the topics you want to revise, read the relevant notes, and practice answering problem and essay questions on those topics. Make sure you get past exam papers as well as read the lecture slides, because you need to follow your professor's guidelines. Your professor may want you to focus on certain cases, and the best way for you to know what are your professor's guidelines is to read the lecture slides and any other materials that your professor may have given you. Grading is subjective, so it is very important that you combine our materials with the lecture slides that has been given to you, and you prepare for your assessments with both content. How can we help? Our team of content creators are successful graduates, law graduates who have been in your shoes recently and achieved high grades. Therefore, they know very well the struggles that law students are going through, and all our content, all our study resources have been designed specifically to help students get high grades in the simplest way possible. We try to explain everything in the simplest terms, in the least condensed, simple manner possible. And we provide exam tips to help you understand how you're supposed to apply your legal knowledge to the facts of the case in a problem or essay question scenarios. Our model answers, example essays, help you further practice and maximize your chances of getting high grades by being able to provide high level of analysis. Tutorial videos are great for visual learners who prefer to learn by slides like I have provided to you today, as well as by listening to the tutor. Quizzes and flashcards are also a great resource to test your knowledge and to practice before you go to your assessment. Study and exam tips are provided to you at every step. If our resources are not enough, we highly recommend you to have a look at our tutoring services, which is a one-to-one Zoom meeting with one of our tutors, where you will be able to discuss any matter that you may be struggling with in your legal studies, whether it's preparing for your exam or whether it's planning your revision or your assignment or doing your legal research, anything you may need help with, our tutors will be able to help you with it. We have already helped thousands of law students get high grades, as you can see on our reviews. We'd like you to be our next student to get high grades. Join Simple Studying now and join our WhatsApp groups to interact with our community and ask any questions you may have. Thank you.